We have this hearing set, as usual, to review the discovery, but we have 3 orders setting trial, and I thought we'd cover those first to see what we need to do on discovery. Does anyone have anything they'd like to cover before we talk about the trial dates that have been assigned? No? Mr. Kavanaugh, I don't know why, but you managed to monopolize the 2 huge Zoom screens on the wall. You're muted too. So, all right. The Sharapov case, the judges set that for October 7th. So what's the status of discovery on the Sharapov case? The court reporter, that is case number A-21-831379-B as in business court.
So Sharapov, it's only against Real Water and the meter defendants. From plaintiff's perspective, the majority of the discovery has been completed as part of the general discovery and the coordinated action. I think to the extent that there's any additional discovery remaining in that one, it's plaintiff depositions and individual questions. But again, that one's only Real Water. It's a pretty clean 2020 usage, so I don't know how much interest there is in spending time on individual causation discovery. I don't know that it's going to even be disputed.
So it's just you and Real Water, correct?
And the meter defendant.
What's that?
Can't have no more.
Yeah. Well, under the court's order, the trial is October 7. Your pretrial is August 29 at 8:30. Calendar call is September 19. Do we even need to set a discovery cutoff date, or do you think you're done?
I don't think.
Hey, Floyd.
Yeah, Joel.
Joel Odou for Real Water. I show a Sharapov set with Judge Hardy on October 7, and I show the Dealman case set for trial with Judge Kishner on October 7, and also the Martinez case with Joe Hardy on October 7. So we do have a potential train wreck coming, and we probably should, I think we have expert disclosure deadlines set in those cases. If we don't, that's what we need to do, is just come up with an agenda. But typically we can't be in 2 places at once, and typically Judge Kishner is not going to be happy if we're scheduled to be in 2 places at once. So I think when Judge Hardy set the case, he was unaware that Judge Kishner has a Real Water case set the same day.
I'm waiting to see what happens when the assignments when Judge Alf leaves. So we understand that Judge Hardy is going to take over the Wren case. It's now consolidated. I think there's 10 plaintiffs or 11, so 10 or 11 total. So we've been waiting to see that to go through, and then what we're considering doing is filing a motion to consolidate some of these cases, because we think the way it's been going, Real Water stipulated liability, and in the Martin case, there's summary judgment on liability as the distributor. So we think it makes the case a lot easier to try, less moving parts. So that we think would facilitate more plaintiffs in one case, like we're doing in the Wren case, 10. So what we're thinking of doing is consolidate them, but we haven't really gone through and decided who to consolidate with. And some of it depends on the judge's schedules. We don't want to consolidate in a judge that will tell us to come back in 2 years. So that's kind of where it is. So I don't think we're going to have the problem that Joel's alluding to. But I don't think we can do the consolidation motion now for the reasons I've indicated.
Joel, I've got I've got the Sharapov and the Martinez case, October 7, but I don't have in front of me. You say there's a third case, October 7, that was previously set?
Yes, it's Dealman and it's with Judge Kishner.
Well, we need to let the judges know that they're doubled up on these. What do you want to do?
I think we ought to put this down, as I understand it, on the 11th, which is coming right up. That's when this transfer is supposed to go to Judge Hardy. So that's when we're starting the other trial on the 16th. But I think, you know, keeping it for 2 weeks and letting Joel and I talk about it.
Okay.
I don't know about 2 weeks,
Well,
because that'll put us.
Yeah, we just been doing so many other things. We haven't had a chance to look at it. But this we want to do. What do you think, Joel?
Look, I don't disagree, Floyd. I just note that Judge Hardy issued an order a few days ago setting the Sharapov case on October 7 and the Martinez case on October 7. And that may have been a mistake. And so we just want to call that to the court's attention.
Yeah, we're gonna have to go in front of Judge Hardy anyway pretty soon on the Wren case, because I don't know if he even knows what he's inherited yet.
I doubt he's looking at these, and I think he's just saying these didn't have trial dates, so he's putting them on a stack. We could, you know, talk it over and work it out, and you know,
You want me to set a hearing in about 10 days, see where we are?
Maybe 2. Well, you know, our problem is we're gonna be right in the middle of the trial right now.
Yeah.
So. No, we could do it, well, 15th is a holiday, right?
Well, why don't you,
we're dark on
why
February.
don't you and Joel try to work it out and just let me know. If I need a hearing, I'll set it.
Okay.
Okay.
All right.
You guys. Just
Yeah, that sounds good. I think if we submit something to the court through you, Floyd, that might go easier. Just as a suggestion.
All right, well, if you want to do stip and orders or recommendations and orders, you know,
Yeah.
a stipulation for me to do a recommendation and order, and probably I'll do one in each of the cases, I guess, even though you refer to the other ones to explain what the conflict is.
Yeah, I think there's also a slight political issue there because Judge Kistner got a little aggravated and we moved, can't remember who got moved out of her court in the Wren case, but she wasn't told immediately, so she got a little annoyed with us. So we don't want to do that again.
The judge was upset they lost a trial.
I don't think she was upset she lost it. I think she was upset we didn't
No one
tell
told
her
her,
quickly enough. That,
so she could correct her calendar.
Yeah.
Yeah, that's pretty important. All right, then I'm going to just give myself a follow-up in about 10 days. In the meantime, why don't you folks to see if you can get together on a stipulated rec and order, and I'll send them over.
Okay.
Sounds good.
Floyd, this is Chad Fears on behalf of Hannah. I just want to make sure that we're also included in these discussions, given that we're also parties in those, at least 2 of those 3 cases.
That's no problem.
Okay.
Of course.
All right, thanks, Chad. All right, anything else?
We got this financial issue on Terrible Herbst.
Oh, on the punitives.
Right.
Hang on.
Good morning, Mr. Hale. This is Jan Tomasik for Terrible Herbst. I'm here to address that issue.
Yes, I received the letters on it.
Basically, it's kind of a catch-22 for plaintiffs every time we go through something like this. You know, we ask for the discovery, and they tell us, oh, you can't have it until the time of trial because your punitive claim is frivolous. And then we get to the time of trial and they say, oh, you can't have it because you can't have it. The status right now is Judge Kishner denied their motion for summary judgment on the punitives. We have a hearing, the order's been drafted, it's been submitted to her, it hasn't been signed yet. But she has denied their motion for summary judgment. So the punitive claim is going to go to the jury on starts January 16th. I think the trial's probably gonna take 2 or 3 weeks, so we don't want to be in a situation where it's midnight on January 29th or 30th or whatever, and do the punitive phase, and Judge Kishner says, where's the punitive discovery? And we say, oh, no, Judge, we didn't think about that.
No, that's
We
the
don't wanna be in
problem
that
is
point. Okay?
that we always have to put that off until the end. A lot of time the courts, if it's in such a monumental case, the courts will do the jury interrogatory, so you have it ruling in 2 phases where they rule if they had the authority to do punitive damages. Yes, we will consider punitive damage. Then you go into the court requiring the production of the financial information, and then that's given to the jury. So yeah, at this point, punitive damages are still in the case, so we're gonna have to produce the financial information. And this is an exception to the normal discovery because on behalf of the defendants, we put that off.
And I don't know what Terrible Herbst's position is, because during the meet confer on a couple other issues, they told us they were not gonna raise an annihilation defense. In other words, they weren't gonna argue that a punitive award
Would put them out of
would put
business.
them out of business. I mean, I don't know how they can take that position without knowing what we're gonna ask for, you know? And obviously what we're gonna ask for has gotta be keyed a little bit by the compensatory verdict. They only have 1 plaintiff case, but they do have a liver transplant claim. So we think that could be a pretty significant compensatory award.
If I may, this is Jan Tomasik for Terrible Herbst. Mr. Hale, we did not get any requests for these documents until long after the close of discovery, right? And that's why we're here days before trial with this issue, okay? You know, we outlined that in our letter. We outlined the case law, so it was not our burden. It was plaintiff's burden during discovery to show some factual basis. They didn't have to wait for any summary judgment motion to be brought on this. And also, you know, the discovery they're now seeking is overbroad under Nevada case law.
Well, it's very common to delay the punitive damage discovery until after the standard closed discovery, and that's for your client's benefit, giving you an opportunity to either settle or the court to dismiss the punitives. And we only allow the punitive financial discovery as a last ditch effort if the defendants are still locked in on a claim against them for punitives. But at this late date, it should be relatively limited. Mr. Kemp, what discovery are you asking me to authorize?
Well, I mean, I still don't know what their position is. I don't know if they're gonna, I can't imagine we'd be asking for more than 250 million, 300
No,
million.
no. You know, I can't do anything about that one or the other. No, what specific documents are you seeking as of
You
now?
know, classic documents would be a financial statement and potentially the most recent tax return. We have the Herbst people listed as witnesses. They're gonna come on the stand and testify. We've gotta have something to talk about.
And I don't have, do you have the specific requests that you've submitted? I have the letters, but did I miss an attachment?
No, it was just the letter request after the motion for summary judgment was
Right.
denied. We asked for 5 years, but I mean, 3 years is.
It should be 2 years, Mr. Hale. The Sherwin case that's cited in our letter clearly states that it's the last 2 years. So if you're going to allow it, it should be 2023 and 2022, and it should be you know, that narrow scope of financial documents that's outlined in our letter.
Where's that at in your letter?
Page 3. Page 3.
Well, I don't mind being limited to the last 2 years. guys given any consideration to stipulating to an amount to avoid all this?
That's certainly something we can talk about later today at your office if you'd like.
Yes.
Gary, let me see
Oh,
the
okay.
page 3 of that. All right, so we have an agreement that the records will be produced for 2 years. And I'm assuming you have financial statements for those 2 years that can be produced.
If that's what you're going to order, Mr. Hale, we will get with our clients and get those, and we would just ask that whatever the order is, it be reduced in writing.
Tax returns are problematic, though.
I think, they're a big company. Their financial statement should be, I would think, fairly credible, especially when they got the gaming aspect of it.
Yeah, that's what I'm thinking.
Yeah.
All right, then I will order, based on the current trial date and the status of pending punitive damages, that you're required to produce financial records for the years 2022 and 2023.
And Mr. Hale, we would also request that a stipulated protective order be entered into, so it's just between plaintiffs and our clients, and this information is only relevant during phase 2, right? So we need to have this confidential and destroyed if we don't get to phase 2 of the trial.
Sure.
Yeah, I don't mind doing that. We've had it. We had the same issue with Michelin and Judge Silver a while back.
So, and sorry to cut you off, Mr. Kemp. I just, wanted to reiterate that we'd request all of these parameters be set forth in writing.
Yeah, I'll put out an order today, and these documents are already in existence. And because the fact that you're going to try to probably seek a review of this, I'm going to require them to be produced within by next Monday.
That's a holiday. That's a holiday.
Right.
Should
Yeah,
we do Tuesday?
Sure.
Thank you.
And it will be subject to the parties entering into an agreed confidentiality agreement. All right, is there anything else? Anyone else? This court reporter, do you have any questions as to anything for the transcript? All right, we're done. Thank you.